Welcome back to Winning Isn't Easy. We're going to talk about the second time around on a disability claim on remand and how one federal judge threw the book at a disability benefit claim administrator who screwed up, who missed deadlines, edited and changed their doctor's reports, and failed to produce requested plan documents. Now, when you take a case on that has been denied to circuit court, federal circuit court, the federal judge can do one of several things. The judge can uphold the denial, the judge can award the benefits, and the judge can remand or send the denied claim back to the administrator or the carrier for a redetermination. I hate that. I just wish the judges would make a decision one way or the other. And this is an example of why I hate it. The judge expects that the disability carrier of the plan gets the message on a remand. And I'm going to talk about the case of Lakey versus the Benefits Committee, which is out of the Southern District of Ohio. Now, this case has been up and down in the court like a ping pong ball. The court found in 2019 that the claim denial was arbitrary and capricious, and it sent the case back to the plan administrator. They blew the deadlines for making a new claim determination. They denied the claim 270 days after the remand. And as a result, the judge decided that the arbitrary and capricious standard of review was no longer applicable, and the judge, were going to exercise their own independent judgment in deciding if the denial was right or wrong. The judge was pissed. Lakey had asked for documents that formed the basis of the claims denial, and the claims administrator didn't supply those until after the lawsuit was filed. That's way too late to do anything with it. This denied her of a full and fair review of her claim because she couldn't respond to the evidence that the plan administrator had relied on in denying the claim and addressing that in her appeal. The judge granted her claim for statutory penalties under the ERISA Section 502C for the failure to provide the plan documents. Now, there was a significant delay, and the judge awarded a statutory penalty of $110 a day and awarded her $40,370 in statutory penalties for not giving her this information. Now, the judge was put off by several other things, one of which was the doctor's opinions were curated to create an after-the-fact reason to justify the claims denial. You can't do that. Either you deny the claim based on what's in the claims file and explain that, or you don't. And you can't create after the denial reasons, post hoc denials, or reasons for the denial, or reasons to justify the claims denial. And worse yet, the judge was put off by changes the doctor made to his deposition testimony that allowed the carrier to further buttress the basis of their opinions that Lakey could do sedentary work. So not only did they curate the doctor's opinions, they curated the deposition, and that really angered the judge. And obviously, the judge awarded her benefits, and her attorney was paid $107,000 in attorney's fees. This was outrageous conduct that really got to the judge, and he really threw the book at him, as he should. So it cost them over $40,000 in penalties. It cost them her back benefits. It cost them $107,000 in her legal fees. And of course, they had to pay their own legal fees. I think that this is a great example of what a disability carrier or a plan administrator should not do in handling a claims file, particularly on remand. In the next segment, I'm going to talk about exhaustion of administrative remedies, exhaustion of your finances, exhaustion of your emotions, exhaustion, and how you just can't blow up your case by saying, I'm out of here, I'm going to federal court first. Let's take a break.